Well, this matter was scheduled to come before the court this morning for an in-person trial today in district court. However, the court was informed that there has been fairly much a settlement of all issues in the case, or at least most of the issues in the case. Ms. Locke, can you clarify the current status of this matter?
Yes, Your Honor, we have reached complete agreements with one exception, and that is how Miss Boyce's personal property will be collected from the marital home. The parties could not agree on that, so we're asking the court to hear argument on that today and then issue a ruling.
Okay, using the first names of the parties for clarification, who needs to pick up property?
April Boyce needs to pick up property from Kira.
Okay. Ms. Levitt, would you agree with the announcement made by Ms. Locke regarding the one issue that remains?
Yes, Judge.
All right. As the proponent of needing to pick things up, I'm going to have April's counsel go first. What do you need to pick up, and how are you proposing to the court that you do it?
Thank you, Judge. There is a property list attached to the party's settlement of items that they have agreed that my client still needs to pick up from the marital residence in some form or fashion. That includes everything from personal items left behind that are small and easily packed into a car, through to furniture such as a queen-size bed and some dressers that is going to require something like a U-Haul truck, and the assistance of at least one other person to do so. My client is requesting the right to go to the personal property or the marital residence to pick up her personal property, and because of a couple reasons. One, when this case started, it was served shortly after the divorce was served. The PFA was served in which my client was kicked out of the marital residence. She had 1 hour to gather her belongings with an officer present. And it was an incredibly hectic 1 hour, an emotional 1 hour, and she was focused on taking things such as her clothing and items she would need for work. She had not been able to return to the marital residence until.
I'm going to stop you right there. I need to pause for a moment.
Sure.
I'll be right back. I apologize, counsel. This should be short. All right. Everyone could resume. Thank you for your patience. Ms. Levitt,
Yes,
if you continue your argument at this time.
Yes. So my client was removed from the home by way of a PFA. She was given 1 hour to get personal property with an officer present during that time to ensure, of course, that she left in compliance with the orders. She was focused on getting her belongings such as clothing and items for work at that time. The PFA since then has been dismissed, and my client was, by agreement of the parties that they had worked out between each other, allowed to return to the home on August 15th to get some items. And the petitioner's position is that August 15th exchange or property pickup, I should say, did not go well, and this should be the basis for my client not being allowed to return to the home. What I would advise the court is that my client had agreed for a third party to be present at the pickup, which was a woman by the name of Carla Barrier, and she had advised the petitioner that her son would be coming with her. His name is Thad White, but that he would remain in the vehicle. When she arrived for the property pickup, Thad was with my client, and he did remain in the vehicle.
Because today we're stepping straight into a courtroom where calm formality instantly gives way to a tense undercurrent. From the moment the judge opens the session, it's clear this isn't just another routine divorce matter. We are told almost everything has been settled, except one deeply personal issue: how April will collect her belongings from the home she shared for years. That single unresolved detail ignites the conflict. As April's attorney steps forward, her narrative shifts the energy instantly, explaining a chaotic 1 hour police-supervised exit, rushed decisions, and emotional strain. The stakes escalate as she lays out April's request to return properly with help and on her own terms.
However, the third party at the pickup was not Carla Barrier. It had been changed by the petitioner to Marcia Barrier without notice to my client. My client said hi to the third party and left it at that. She picked up property. There was no fight. There was no issues between the parties during that pickup. However, we're being advised that my client was inappropriate to the third party, that she brought along her son wrongfully, and that is the concern going into another property pickup. Our proposal is that a neutral third party be hired by my client, such as a private investigator or an off-duty police officer, to be in charge of the not in charge of the property pickup itself, but to be present and ensure that it remains neutral and nothing inappropriate occurs, that there is no inappropriate conversations or interactions, which again, my client is offering to pay the cost of. The reason why she wants to actually go to the marital residence to get her property is to ensure that she's actually getting all of her belongings. Otherwise, what's going to occur is potential future litigation when the petitioner packs everything up, places it in a storage unit or a moving truck or a pickup truck or something for my client to receive. And then my client has to inventory all of that. And if items are missing, we have to litigate that issue. This allows my client to go to the marital residence that the parties lived in for 8 years together, that she had only 1 hour to get out of and has barely been back to since then, get all of her belongings, and anything that she leaves behind at that point can be considered abandoned and done. As to the concerns as to who might come with my client or the petitioner not wanting to interact with my client, I think this past weekend really undercuts that. This past weekend, my client's son, who is an adult, I do want to be clear on that, he is over the age of 18, but my client's son had a BMX tournament.
Our grandson did.
A grandson did, excuse me, but the child of my client's son who was present at the pickup had a BMX tournament. The petitioner voluntarily showed up to that event knowing that my client was going to be there because it was her children and grandchildren who were doing that event. She briefly interacted with my client at that event with no issue, and she interacted with my client's son at that event with no issue. We've been told by the petitioner she wants to maintain a relationship with my client's children and grandchildren. And yet we're being told that my client bringing her son to the pickup was one of the issues that was inappropriate. And that is compelling them to say she shouldn't be allowed at the residence, and that my client was not appropriate with a third party. I think those issues are addressed by the fact that it would be a professional, and that the person who my client would have come with her is her son, Thad White, who the petitioner knows. And
as April's attorney continues, the tension sharpens. She paints the August 15 pickup as uneventful from April's perspective, yet now being weaponized against her. She breaks down every detail: the third-party switch, the son staying in the car, the absence of any confrontation. Her tone is precise and deliberate, dismantling the idea that April created any disturbance. Then she pivots to their proposed solution, a neutral third-party security presence, fully paid for, ensuring a professional and controlled environment. The commentary grows more pointed as she argues April deserves the dignity of sorting her own belongings inside the home, avoiding future disputes and accusations. Bit by bit, the courtroom shifts as she reframes April not as a risk, but as someone simply asking for fairness and closure.
by this weekend has demonstrated wanting to continue an ongoing relationship with, and clearly does not have concerns or fear of, if she voluntarily went to his child's event and interacted with him. We believe that she should be allowed to go to the marital residence and move herself out. I think that that's a dignity that in this divorce, both parties should be entitled to, and the petitioner is just fortunately not having to move out of the marital residence because it's being awarded to her. But to have the right to pack herself up and move her belongings out and ensure she gets everything at her own expense is something that we do not believe is too big of an ask. We think it's appropriate under the circumstances. The PFA was dismissed. These parties have reached a settlement, partially through mediation, partially through counsel, but ultimately through their own accord by starting to get along and see eye to eye. There is not a risk here when we involve that neutral third party, and we're just asking for that right. And again, I would emphasize, I think it'll eliminate any issues post-divorce decree that there is property unresolved being withheld from my client or wrongfully disposed of in any way, because the burden will be exclusively on April to ensure that she has gotten what she wants and that one go, and that anything left behind is done. That's abandoned, and it's either the petitioner's or the petitioner can dispose of the same.
All right, Ms. Levitt, a couple of questions come to mind. Is a date and time for the pickup already established?
It is not, Judge, because the petitioner had suggested, and I don't want to put words in Ms. Locke or her client's mouth, but the petitioner had suggested that the property be moved to a storage unit, which would not necessarily require a set date for the petitioner to do it, whereas a pickup from the respondent going would require a set date to do so. And so we had not picked one because it'll ultimately depend on what you decide. My client can schedule the same quite quickly. We would likely pick a Saturday or maybe a Friday, depending on a Saturday would be better with her work schedule. That would be preferred. I don't know, Judge, that I can coordinate a neutral third party for this Saturday plus a U-Haul. It is more likely that the 4th I could coordinate all that for. That would be so this Saturday is September 27th. So the Saturday after October 4th would be far more likely to have both of those parts properly scheduled.
The courtroom mood shifts when the judge jumps in with direct questions, drilling into logistics, dates, times, limits, clarity. April's attorney answers with steady confidence, outlining schedules, the need for a Saturday pickup, the practicality of October 4th, and the importance of an itemized list. She emphasizes that April understands her boundaries. Everything must come from that agreed-upon list, nothing more. What makes this moment compelling is how the argument evolves from emotional history into concrete planning, turning chaos into structure. The judge scrutinizes each detail, testing the readiness of April's side, and each answer strengthens the case. By the time the judge turns to the opposing attorney, the atmosphere is thick with anticipation. Will the other side push back or fold?
All right. Second, it would appear that there is a detailed, itemized list of items of property that your client's allowed to pick up. Is that correct?
Yes, Judge, that is correct.
And does she understand that she'd be limited to the items on that list?
Yes, Judge. The only thing that I'll tell the court that I believe is detailed enough and the parties don't have a disagreement on this issue, but just for the court's sake, is there is an item listed as April's personal items, clothing, shoes, pictures, small hair accessories, jewelry, personal framed pictures, etc. I suppose theoretically that could cause dispute if they both say that a certain family picture belongs to both of them. But we actually do not foresee that occurring. I think it's quite clear to the parties what is petitioner's property when it comes to personal items and what is respondent's. But besides that list, everything else on the list is very clear, and my client understands that those are the only items she's allowed to remove from the home.
Thank you, Ms. Levitt. I'll turn to Ms. Locke at this point. What is your client's position regarding the proposal that's been made to the court this morning?
Yes, Your Honor. Obviously, we're here today because my client disagrees with the proposal. When this case was served on the respondent, the temporary order said that the marital home would be where my client would reside. April Boyce then barricaded herself in the home. She changed the locks on internal doors. She refused to leave the house, despite attempts by the police to ask her to leave voluntarily. She made accusations that my client abused her, which ultimately led to the PFA being filed and her being removed from the home. After she was removed from the home, she requested pretty significant amounts of personal property, so clothing, personal items, those types of items. Miss Kira freely gave those to her, brought them to my office. An individual from Miss Levitt's office picked those things up. We reached a property settlement agreement as far as personal property goes very early in this case, approximately 5 months ago in April. However, April never came to pick the items up. She never wanted to pick them up. She never made arrangements to pick them up. Since then, she's been out of the marital home for 7 months. She's had 60 days in a rehab facility. And the long and short of it is that my client doesn't feel safe with her being in the home. Emotionally, they have separated from each other. She is not comfortable with her returning to the home, with her disrupting Kira's life that's going on in the home, including their animals and their pets that are all being awarded to Kira.
Now the opposing attorney steps in, and the tone immediately hardens. She reconstructs the history differently, painting April as someone who barricaded herself in the home, changed locks, refused police requests, and triggered a chain of events that left her client feeling unsafe. She pushes the narrative that April's behavior was unstable, that items were long agreed upon, and that April simply never picked them up. Her proposal sounds cleaner, controlled, a storage unit, paid for, allowing both women to never cross paths again. The way she draws contrasts is sharp: emotional stability, safety, predictability. She even references how April handled property division in her previous marriage, aiming to undermine the other side's logic. Each detail adds friction, leaving the judge with two opposing realities.